All right, the court is calling 2025 CR 00736 State versus Pete Ortega. Can I have parties announced?
Raymond Martinez from Mr. Ortega.
And are you Mr. Ortega?
Yes, I am. May he sit, Judge?
Yes.
Go ahead, sir. Mr. Chair.
You might want to hold on.
Sorry.
All right, counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
All right, in probation, there are no applications. Court will find that the state is in compliance with discovery. There is no indictment. Oh, here we go.
Sorry.
Mr. Ortega, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sure.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented? Mr. Ortega, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yeah.
Counsel, has your client been able to provide any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ortega, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
The court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 7 days in the Bexar County Jail under 1244. There are no applications and no fine. Did you understand that to be your plea?
Yes, sir.
Defense and state?
Yes, sir.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State proceeds Exhibit 1 and all attachments.
Objection, Your Honor.
Right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, we'd ask the court to follow the plea agreement. Mr. Ortega admits that he was in possession. It was less than half a gram. He self-medicates. He's got neuropathy in his legs. He's got missing cartilage in his knees, and he's got sciatica. All of that is what explains why he gets around so gingerly. And he's only 62 years old. So he suffers, and he understands that that's not the way to medicate, but sometimes when you're in pain, you do what you got to do.
Yeah.
So despite the somewhat leniency of the plea offer, we'd ask the court under the circumstances to follow the agreement.
And sir, who is Miss Yepes to you?
She Yepes.
Yes.
She's a friend of.
Oh. All right. Then this is what the court will do. The court will follow your agreement. The court will sentence you to 7 days in the prison. I'm sorry, not prison,
Yeah, no.
Bear County Jail. Give you credit for any time served, and I'm sentencing you under 1244. And is this a judgment
I
satisfied?
believe
Yes,
that's
sir.
it.
The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, so sir, I understand, the state of the healthcare system and not being able to afford certain things. But taking illegal substances is not good. And the reason why it's not good is because you never know what you're getting.
Yes.
And anything could end up happening, okay? So you can go to the emergency room, and I know people say, the emergency room is really not primary care, and I know that puts a strain on the system because people are just going in the emergency room instead of taking things up front. But if you don't have health insurance, that's probably the best place for you to go.
Yes, sir.
And I always recommend, I know sometimes people are saying, oh, you need to go to this hospital, this hospital. Public hospitals, like university, they are always up to date on coming technology and new things because the government usually gives them research funds. So you may want to try it, okay? All right, good luck to you, sir. You're welcome. All right, so on this case, have you all had, all right, the court is calling 2024 CR 5108 State versus Randy Gallegos. Can I have parties announced?
Madam Credit State. Austin Hagan for the defense.
And Hannah Hawkins for the defense as well.
And where is Randy Gallegos? All right, y'all are scheduled for jury trial. The defense has filed a motion to dismiss for failure to comply with Article 39.14. State, have you had a chance to review the defense's motion?
We have, Judge, we have a brief argument response.
Yes, what's your response?
Basically, Judge, I've printed out the case that was cited to by the defense motion. That would be State v. Heath, citation 642 Southwest 3rd 591. I could pretender a copy of the court.
Yes.
And I'm also providing a copy to defense. And Judge, in reviewing the defendant's motion, they cite to a failure to comply with Article 3914 of the Code of Criminal Procedure because pursuant to the Texas Administrative Code, breach of the peace are required to be reported to TVC no later than 24 hours after the incident involving serious bodily injury. Judge, in reading Heath, I don't believe that dismissal of the case outright is the appropriate remedy. Heath, if you go to the tab portion, it states, in other words, even though lesser remedies might suffice to cure harm, the most extreme remedy of exclusion is required only if the record shows the prosecutor intentionally violated the order in a calculated effort to frustrate the defense.
All right, so here's my question. Number one, when were you made aware of the TABC report?
I have to review my notes, Judge, but it would have been about a few weeks ago when I was preparing for trial. I was talking with the complaining witness, and he mentioned for the first time that there was a TABC report that was made to Agent Maggie Centillion.
All right, and so when you learned of this information, what did you do?
I filed a memo of disclosure that day, and that memo of disclosure was sent to defense. And I also called Agent Centillion on the phone number that Pete Rios provided me with. And I left a voicemail. A few days went by. I left another voicemail. A few more days went by, and I talked to Lieutenant Jeffrey Talley, who is in the Austin office of TABC. I left a voicemail with him saying that we needed this report. After that, I didn't hear much back. And then yesterday, I realized that TVC report had never been brought back to us, so we filed for a subpoena and they've been served this morning. And I'm being told that they're going to comply with the subpoena.
All right. Anything from the defense?
Yes, Your Honor. In our perspective, I understand that the state recently spoke to their complainant a few weeks ago and found out about this TABC report, but they've had this case. It allegedly occurred September 2022. It was indicted by the grand jury in 2024. So they've had 2 years since the date of indictment and longer if you consider the period of investigation to obtain this report. The detectives spoke to the complainant, could have found out about the TABC report at that point. The incident occurred at the bar, so that is a line of questioning that should have been pursued at that time, and certainly something that should have been looked into by the state prior to a few weeks ago when they were pre-trialing their complainant. It is within the state's possession as it's within the records of TABC, which is a state agency. So for those reasons, we're asking that the case be dismissed for failure to comply with Article 3914.
All right. All right, motion to dismiss will be denied.
Your Honor, we would ask that any mention of the report or testimony about a report made to TABC be suppressed and not admitted into this trial.
All right, then the court will make a ruling on that once the report is received by the defense.
Yes, Your Honor.
And my understanding is you all will have that report today. And once y'all receive the report, you may decide that you do not wish for it to be excluded.
Sure.
All right. So there's a plea on Mr. Ortega. We'll take up that plea first. And then each side, 20 minutes.
You only have 30, Your Honor?
I'm sorry.
I think we're both present 30 minutes, Judge.
All right, sure. 30 minutes. And Norma Oliva?
Norma Stefanovic.
No, I'm talking for the defendant. Can you make an announcement outside in the hallway for Norma Olivia? I forgot to pronounce all vowels.
Just give me 2 minutes to prepare this plea.
All right. And so the charge in this case is aggravated assault causing serious bodily injury.
Yes, Your Honor.
Okay. All right, so both sides, what we'll do is we're just going to do jury selection today. The state should have that 1-page report and you all will have a chance to review it. And then we'll do testimony beginning tomorrow.
Thank you.
You're welcome.
Judge, state will have all of its which breaks.
They're going to need a chance to review whatever report. So, sure. All right. Thank you.
Your Honor, we do have a motion in limine. Would you like that to be heard now or
Uh,
after the jury's and
The motion in limine, what is it in regards to?
Your Honor, I can tender a copy.
Thank you.
My filing got returned this morning, so we're